The strategies and concepts discussed are for educational purposes only and do not represent specific investment, tax, or estate planning advice. Investing carries an inherent element of risk, and it is in everyone's best interest to consult a tax, legal, or investment professional. John Cyndia is an investment advisor representative of, and advisory services are offered through USA Financial Securities Corp., member FINRA SIPC, a registered investment advisor. Life Stages Advisory, Dean, Remington, and Danielle are not affiliated with USA Financial Securities. Welcome to the 29th episode of WTF, Wealth, Taxes, and Finances. I'm your host, John Cyndia, certified public accountant and personal financial specialist. I have with me again in the studio here Danielle Frye with Krugliak Wilkins, law firm in Canton, and also in Ohio and Florida, right?
Well, yeah. So I'm licensed in Ohio and Florida. We don't actually have a location in Florida, but we have several attorneys that are licensed in both states as well as
great
other states surrounding.
What we're going to do today, we're going to talk about trusts. So it's going to be everything you wanted to know or were afraid to ask about trusts and how they work, what types you would need in certain circumstances, what do they do, why do we get them, and I'll go back and forth here with Danielle on a listing, and then we'll talk about each one for a few minutes and get into that because there's actually like 30 or 40 probably if you got into different types of trust, and we're going to concentrate on maybe about 12 to 14 different ones, and they're pretty important from that standpoint. And what I normally do at the end is ask you to like us, watch us, spread the word about this, but I'm going to do that now at the beginning of this, because I keep forgetting. So I hope you guys learn a lot from our podcast and our video that we've started here about 5-6 episodes ago. And just, like us, love us, do whatever you can. And
subscribe.
Subscribe, yes.
Follow.
See, that's Dean, okay. Rem's in here too today. So those are my voices of consciousness. Or consciousness? Maybe that's what
something like that.
Something like that. It's Saturday, okay? It's a rough morning here. Anyway, Danielle, let's start with a testamentary trust. Tell me a little bit about that and how that actually comes about.
Right. So before we get into that, I just want to point out generally what a trust is. A trust is a fancy word for an estate planning contract.
Okay.
So in its simplest terms, there's essentially 4 major things that a trust typically involves. The first is the creator of the trust. So whether it's a settlor, a grantor, there's various terms that are used right now under Ohio law that the term is settlor. If you are working with a testamentary trust, which I'll explain in a second, that's a trust under a will, that would be a testator creating that trust because that's who creates a will. So you have the person creating the trust, the trustee, so the fiduciary in that relationship, the one that's overseeing the administration of the trust and handling of the trust assets. Then you have trust property. So there has to be some type of property to be held in the trust. Okay. And last but not least, you have the beneficiaries. So the person or persons or charity, whatever entity or person the trust is being administered for the benefit of. So that's why the term beneficiary is they're the ones benefiting from the trust.
Gotcha.
So a testamentary trust is a trust that's created under a will. And so that actually wouldn't be created until the person that made the will passed away.
Okay.
So in Ohio, if you have a testamentary trust, the probate court would have ongoing supervision over the trust administration.
Okay.
And what I mean by that is that the trustee would have to do reportings to the court about how the trust assets are being administered. They have to file accountings, at times request permission to make distributions out to the beneficiaries or to pay, their fees, the trustees' fees, any other type of expenses. And so it's a little bit more restrained than an outside of a probate court trust, so something other than a testamentary trust. In other states, however, the court will have supervision while the trust is being created, but once the trust is established, that supervision kind of goes away. So some other states do allow for administration of a testamentary trust without being under the court supervision. But in Ohio, that's how it is.
So when it's created through that will, it still is having to go through probate then,
Right.
Is that right? Okay.
Yeah.
So if you don't do the planning properly to avoid the probate, it's going to do it for you by terms of that will.
Correct.
Okay.
Mm-hmm.
Okay. How about a special needs trust?
Yeah, so there's several types of special needs trusts in Ohio, and just like the other types of laws, they're pretty consistent throughout the states, but each state has their nuances. But the typical special needs trust that I would assist a client in preparing is what we refer to as a wholly discretionary trust.
Okay.
So in Ohio, that's a type of trust that you can create for a beneficiary who might be disabled or might be entitled to receive some type of public benefit, maybe Medicaid or SSI, supplemental security income. And you want that beneficiary to still be able to receive an inheritance or gifts maybe from grandparents or parents if they were to pass away, or it could even be during life. But a lot of those public benefits, there's some type of resource limit that the person that's receiving the benefits can receive or own.
Okay.
And so that type of trust would allow gifts to be made to the trust without affecting their eligibility for those public benefits.
Gotcha.
And the reason it's called wholly discretionary in Ohio is because the trustee has complete discretion whether they want to make distributions or not. And so that's why it permits, that's why, Medicaid, for example, would allow that type of trust, even though, the person, the beneficiary, is receiving those public benefits.
Okay. All right. There's a revocable trust and then there's an irrevocable trust.
Yes.
And then at some point in time, upon the death of the individual that has the revocable trust, it becomes irrevocable.
Correct.
So could you explain, I guess, how we would make that transition and when would I want just an irrevocable trust?
Yeah, so a revocable trust is also known as, it can be known as a living trust. And it's exactly what you said. Essentially, it can be changed just as a will can up until the day the person dies. And so typically, for tax reporting purposes or, just simple administration purposes, a revocable trust is just an extension of oneself. So if I had my revocable trust, I would still use my social security number for any account that was owned by the trust. And so it's essentially just an extension of me. When I pass away, that trust becomes irrevocable, which means that nobody can change it. Whatever is in the trust is what the trust provides. And at that point, typically there's assets owned by the trust. And so we need to have some type of tax ID linked to that trust because my social security number can no longer be used because I'm dead.
Okay.
So at that point, you have to have a new tax identification number. And so that actually gets reported to the IRS. And so it's a process. So typically when somebody passes away, the trustee steps in, whoever the successor trustee is, they get the authority to act and start collecting assets or changing, the asset titling depending on how the assets are titled when I pass away. But at that point, it's their job to just administer the trust according to its terms.
Okay. What about a charitable trust? Can't I just sort of dictate what would go out through a trust, or how would the charitable trust differ from that?
Yeah. And so you asked me an additional question on that last set of questions that I didn't really get to. So an irrevocable trust, taking out of the picture, a revocable trust becoming irrevocable. If I were to just create an irrevocable trust today, those types of trusts, there's different purposes, but they're typically used for some more advanced planning. And what I mean by that, it might be we're doing some long-term 5-year planning for eventually going into some type of long-term care facility, and we want to protect assets.
Okay.
It could be I'm subject or will likely be subject to estate tax when I pass away, so I want to try and gift some assets to an irrevocable trust now to help limit my estate tax liability. And so there's a lot of different reasons to use irrevocable trusts, but that's why, they're structured differently than just a revocable living trust.
Gotcha.
So a charitable trust, in general terms, is just a trust that's for the benefit of a charitable beneficiary.
Okay.
And so they can be structured, again, in many different ways, but a lot of times you can receive either an income tax or an estate tax or both benefit from creating that type of trust. And so, with clients who have an interest in charitable giving, and maybe they also have some potential estate tax liability, that's a good vehicle for them. You don't have to have that estate tax liability, but that's a lot of times when those types of trusts come into play.
Okay. So it sounds like you can have several different trusts at one time, or one individual can. If that's the case, is there one instrument or one trust you could create that would, upon the death of that individual, create all these other ones?
Yeah. So, if I wanted to have a revocable living trust as well as during my lifetime an irrevocable trust for any of those purposes we just discussed, we would have to do that, unfortunately, under two different trust instruments. Okay. But let's say when I pass away, I want there to be a trust for my child to be administered for my child's lifetime. At certain age, 25, they become their own trustee, but I want it to be protected for them from creditors, or if there's a divorce, I want those assets to be protected. But I also want a charity to receive a certain percentage of my estate. Okay. So my revocable trust can essentially provide for the creation of what are called subtrusts. And so those actually get formed after I pass away. They will each have their own tax identification number, so they're each their own separate entity. And that doesn't require me to, create 6 different trusts during my lifetime for what will happen when I pass away. So there is a mechanism there. It just kind of depends on, the overall goal. And
how long do the trusts last then? Until there's no more assets left to spend for the benefit of what they were set up for? Or how do I collapse one?
Well, so yes, technically a trust can go on for forever.
Okay.
Typically there happens to either you run out of trust assets, so the assets get spent down, or there's no more beneficiaries. So if I create a trust for my descendants and, my child maybe has one grandchild of mine, and then there's nothing after that, at some point the trust will terminate. But in Ohio, and I think this is consistent with most states, there's a statute that basically says if the trust assets get below a certain amount to where it's uneconomical to administer the trust in that manner, then it can just be distributed out and terminated.
Gotcha.
There's ways to go about terminating a trust not using that mechanism, but that's typically.
I've had some individuals talk about dynasty trusts. Mm-hmm. Now, explain to me what that actually is.
Yeah. So that type of trust we technically probably structure it as an irrevocable trust. Okay. And so let's say I want to create a dynasty trust, I would create an irrevocable trust that's for the benefit of my descendants. And so I would gift a certain amount of assets into that trust. And I would obviously at that point file a gift tax return. So it shows that I'm making the gift. Mm-hmm. But the purpose of the dynasty trust is to get the most beneficial treatment as it relates to the generation skipping transfer tax.
Okay.
So obviously I have to report that initial gift, but the growth essentially grows within the trust, and I don't have to keep using my generation skipping transfer exemption as that trust grows. And so it passes more funds, more assets on to later generations.
Gotcha. Okay. And since you brought it up, let's go a little bit more into that generation skipping situation.
So fun.
Yeah.
Actually, in law school, it was so funny. When I was taking my wills and trust course, my professor told the class, well, I'll teach this to the class, but it's less than 0.5% of individuals that end up having to deal with these tax issues. And so, we'll talk about the logistics behind it, but you don't need to really focus on it. And I think we had like a really condensed section on that on our final exam.
I'm glad to hear that, because now that you're saying that, I was worried that I may have missed it at some point, but I've never really encountered it.
Yeah. Well, and so I guess I'm lucky that I have out in practice, but yeah, it's then that at that time when I was in that course, it was when the exemption was a little over $5 million per person. And so since then it's doubled. So I assume that percentage of people that are actually taxable has fallen. But yeah, so right now the generation skipping transfer tax exemption is the same as it is for the estate tax exemption. Okay. So approximately or a little over $11 million per person. Okay. And so if you're a married couple, the married couple, the wife would have $11 million, husband as well.
So that we really shouldn't have to worry about that quite a bit anymore.
You're lucky if you have to.
Yeah, I was going to say, if you have to, don't complain about paying the tax.
Yes. But, if you hit the lottery someday, maybe.
Yeah.
And typically, historically speaking, the generation skipping transfer tax has been consistent with what the estate tax exemption is.
Mm-hmm.
So if the estate tax exemption does fall back to the exemption it was before, a little over $5 million per person at the end of 2025, it's likely that, whatever happens with the estate tax exemption, the GST exemption will follow.
Let's see. I've heard sometimes that people have like they call it a qualified personal residence trust, and they're putting a house or some property into it. When is that beneficial and maybe not going into some other type of vehicle?
Yeah, so that's typically when we're dealing with estate tax liability. And so it basically will allow gifting of the residence into this type of trust. And once you make it past a certain number of years as provided for in the trust, then, you don't have to worry about that being includable in your estate. And so it can still be used for the benefit of the family. But it's just no longer in your taxable estate assets.
Is that typically when somebody will have a life estate in a residence or anything? Or is that different?
That's different. Okay. Yeah. So back, I guess in the early 90s, it's not as common today. I'm sure some attorneys still will structure plans this way. But, when long-term care planning was not what it is currently, when there weren't as many vehicles and we didn't have the law, I guess, as structured as it is now. A lot of people would gift their residence or the remainder in their residence to the children so that they only, for purposes of qualifying for Medicaid or public assistance, they only had the value of the life estate in their resource amount.
Gotcha.
And so there's some benefit there, but now a lot of times people will actually just create an irrevocable trust, which is a little bit different than the qualified residence trust. But for this purpose, they create an irrevocable trust and actually transfer their house to that trust. Okay. And then that protects it for purposes of Medicaid qualification.
Okay. All right. A couple more here. An asset protection trust. That's probably on the lines of that qualified personal residence trust?
Yeah, so I would couch that, I guess, into two pockets. So I get generally speaking, an asset protection trust is just a trust that attempts to protect assets. Okay. In Ohio, we have what's called a domestic asset protection trust. It's actually called a legacy trust in Ohio. That's the statute. I think that became effective in 2013. Ohio was permitted to start doing those. They've actually been dynasty, or the legacy trusts, domestic asset protection trusts have been around for a while. It's just various states started getting ahead of others. And so I think maybe Delaware was the first one to allow for that in the states. But essentially, it would allow you to gift assets. You can still have some interest in the assets, but it protects it from outside creditors. So if you were to get sued, anything in that trust would protect it, and your creditors wouldn't be able to attack that. So it's essentially similar to creating like an LLC or some type of entity. But then there's also asset protection trusts for purposes of long-term care planning. And so in my practice, those are the two, asset protection trusts that I deal with the most. Okay.
All right. And then I guess when they're doing that, does that necessarily have to be an irrevocable situation with those assets in there?
They do, because you essentially have to gift the assets away. You have to, unfortunately, give up control to those assets, because if you have control, then it makes it easier for your creditors, or it makes it easier for Medicaid to treat it as an asset of yours.
Okay. Finally, the last one I want to talk about, and we've had a situation come up a couple of times that we've done that, is a defective trust. Mm-hmm. And I think it's very interesting. Give me how it functions and why I'd want to have a defective trust.
Right. So I think the full term is intentionally defective grantor trust. And so this type of trust, again, it's typically when we're dealing with potential estate tax, maybe some capital gains issues. So it's a tax planning vehicle. But essentially you could gift assets, and for purposes of estate tax, it's treated as a completed gift.
Okay.
But for purposes of income tax, it's still treated as being taxed to the grantor or to the creator, the settlor of the trust.
Okay.
And so it allows the settlor or the grantor to continue to pay any income tax liability owed on those assets, thereby getting assets out of their name because they're using the assets to pay for that income tax liability. Okay. But the gift is having been treated as completed for purposes of estate tax. And so it allows you to, let's say you have a business interest, you can freeze the value of the assets at what it's gifted in for purposes of your estate tax liability. But then you can continue to pay into the trust by making payments on the income tax that might be generated from the growth of those assets.
Gotcha. So I can still utilize that, because the nice thing about it is that for those who aren't aware, the trust taxes are graduated, but I think at around $10,000 or $12,000, they're at their maximum 45 to 50%. Mm-hmm. So you're going to have a lot lower personal tax rates, and then, as Danielle said, upon death or anything, they're already assumed out of the estate and everything. So it's a pretty good planning technique that we've seen. Well, that's, are you guys still awake back there?
Glazed over,
Glazed
John.
over. But
no, that's great information.
Yeah, I think that's, from the last 2 episodes we had Danielle on, I think that's gotten a lot deeper into it, a lot better explanation. And I hope everybody else listening here derive something from that. And if you did, like us, love us, like I said, and we'll have Danielle on. We've got another episode coming up today, but you'll get it the following week. And we're going to be talking about more specifically about nursing home situations and everything, and what we have to look at for Medicaid planning, VA, and just about anything else that could hit a situation. So until next time, thanks everybody, and remember to like us. Thanks, bye.